All right, okay. Welcome to Write Right, a 3-day webinar series on referencing and legal drafting. Okay, so this webinar is brought to you by Loctopus and Loctopus Law School. For those who do not know about Loctopus, Loctopus is a 14-year-old organization. Okay, and it was founded by Mr. Tanuj Kalia, who is a keynote speaker, founder, author of a very influential book. Okay, and Loctopus Law School was started in 2020, where now we've served more than 20,000 learners with an average rating of 92.5 out of 100. We have been serving learners and filling the gaps of law schools since 2020, and with feedbacks and with proper understanding of what is missing, we keep evolving and keep developing our courses and our products and our training programs accordingly. Okay, now very recently we have also launched a training program for which I am going to be telling you at the end of the session. Okay, now as I have always told my learners in sessions, I'm going to tell you as well, there are two choices that you have. Okay, either you just sit with your video, of course your video is always going to be off, but with your, like, just phone or your laptop just there on the side, and you're doing 100 things, eating, probably just roaming here and there and watching and doing everything just for the sake of a certificate. Maybe that's something that is your choice. Okay, most of us end up just hoping for jobs and hoping for financial success and hoping for internships, and with actions like these, the hope never gets translated into reality. Okay, so hoping is not a good strategy. So first choice is either just doing what you're doing, continuing to doing what you're doing, and just moving ahead in general. And other choice is that you actually pay attention to today's webinar and take notes and make a decision in your life. Okay, so the choice is completely yours. All right. Now, at the end of the webinar, I am going to be showing you an opportunity. I'm going to be giving you an opportunity to take a step towards your career and towards transformation of your life. We have a bonus registration opportunity at the end of the webinar for half an hour. Today is the last day. Okay, today is the last day of this offer. We're giving a double offer opportunity, which is a new year offer as well as the webinar offer, plus 2 free courses along with this winter training program. Okay, so we have a bonus registration opportunity for registering in the winter training program, which is a training program which will happen over a period of 1 month. Okay, this year we had the summer training program, which was a huge success, and then we decided to get start our winter training program. We have 3 verticals in the winter training program, that is litigation, corporate, and budding lawyers. I'll be telling you about all the 3 verticals and all the USP of this winter training program. You can take advantage of this bonus registration opportunity at the end of the session, and do not miss out on it, because this is something which will not happen again. Okay, this is not going to happen one more time. Okay, now for today's session, we're going to be learning about legal notices and legal notice drafting. Okay, make sure you take the most out of this webinar content wise, and the advantage that we have in the last half an hour, that is also really important. So please stay tuned. Make sure you take take this decision today and implement it. Okay, all right, now today we have advocate Vishakha Girhe. She is an independent litigator. She's currently working at Nagpur. Okay, there's a bench of Bombay High Court in Nagpur. Okay, she's completed her LLM in business law, where she was a meritorious student, completed in 2018. Okay, currently she's also working at Loctopus Law School as a learning manager, and she's also the faculty for the civil drafting and civil proceedings course. Before joining Loctopus, she was working as the research associate in All India Reporter, which is India's oldest law publisher, okay, where she developed many courses, okay, and she taught legal drafting to students and professionals, okay, on criminal legal drafting with respect to civil and criminal, and many other research related courses were developed by her, okay. Now today we have her where she's going to walk us through the entire procedure of drafting of a legal notice. And I am super excited to look forward to this learning from this session, and I hope all of you are as well. Okay. Now, few logistics that you also should know. Please post in your questions in the Q&A box. Okay. If you have any responses to give, make sure you do it in the chat box. Okay. Uh, Please don't put your questions on the chat box because otherwise it might get lost and we don't want to miss out on your questions. Okay. Adona is asking what about the fees? Okay, now fees of the winter training program, I'll tell you in detail. Okay. Uh, I've already told you that this winter training program has three verticals: litigation, corporate, and budding lawyers. Budding lawyers is for people who have just graduated or who are still in law school and want to excel and have a great CV. Okay. The we also have three magical points in this winter training program. Okay, first is that we have partnered with law firms of particular verticals. So litigation has partnered with litigation firm, corporate may corporate firm, and budding lawyers we have partnered with an organization where each of these law firms and organizations are going to take sessions, and then they are going to give you projects. On the basis of that project you will be getting a certificate from the law firm as well. Okay, so you'll be getting two certificates. All right, the fees for the winter training program is 9,900, but we are giving double offer in this webinar. First is with respect to the new year offer where 1,000 rupees is off, and then in this webinar we are making 1,000 rupees more, 1,000 rupees off, so that makes a total of 2,000 rupees off with two other complimentary courses that we're giving for free. Okay, so that's the fees. Now, without any further ado, all of these details I will give you in a better manner at the end of the session. Okay, great. So now we're going to start the session. All right. So let's let's be ready with our pens, with our notebooks and water bottles, and over to you, Vishakha. Looking forward to this session.
Thank you so much, Angsha. I welcome all our attendees for today's webinar. So today's session is on legal drafting. Okay, so all the budding lawyers that we have with us today, when you are trying to, or you are interning at a law firm, legal notice or drafting of a legal notice is something where you can ask your seniors or everybody there that this is an area where you would like to try your hand, and without any hesitation they will allow you to do that. So as far as the legal notices are concerned, let me make one thing very clear to you. This is a kind of an anticipation that one person has in his mind that there might be certain dispute with the other party, or this is an area where I'm not happy or content with the other party, the way in which our business is working or our relationship is going on. So it is important that we let the other person know that there is a disagreement, and I intend to sue you in court. Okay, so instead of directly going to the court because you have a disagreement with the party, giving them a notice is what a concept of a legal notice is. Okay, just because there's a disagreement, it doesn't mean that you'll go to the court and sue the party, and then directly the thing is adjudication, which will be done by the court. So this is for one step wherein the other party will get a chance, okay, to understand what your problems are, or wherein certain conclusion can be drawn between the parties, or there can be the dispute can be amicably solved between the parties. Okay, so I will just start sharing my screen wherein we can discuss the significance and other details of drafting of a legal notice. Can you all see my screen?
Yes, Vishakha, it's visible.
Okay. Okay, so like I said, that it is where the legal proceedings are initiated, or at the at before the legal proceedings are initiated, a legal notice is sent to the other party. Okay, it is a cost-effective tool for dispute resolution. As it happens that this party A and party B are into an agreement to sale. Okay, and both of them are doing their part of contract, so they are in a way trying to perform their part of contract. But if A is not happy with the manner in which B is okay working, or B is not happy with the manner in which A is performing his part of a contract, then in that case there is going to be a disagreement. So it is important that you communicate it to the other party. So the disagreement is there, and it happens when there are two or four people working together. There are chances that there are going to be certain disagreements, but the disagreement is or has become of such a nature, or it has troubled the other party to such an extent that party B is thinking to sue you in court, is what A should know beforehand. Okay, he should not be directly served with the summons of the court that come and file a WS against a plaint which is filed against you, but he will be sent with a legal notice wherein he'll understand that okay, B is troubled to such a level that he is thinking to sue me in court. So that is what, this is where A is supposed to get a notice of it, and that is what the importance of legal notices. Okay. Next, it provides clarity in resolving disputes. Now, when B is sending notice to A, in that case, B will say that this is A, B, C, D, or point 1, 2, 3, 4. This is the area of disagreement. I'm not happy in the manner in which you are doing your deliveries, or there is a problem with that you're not disciplined enough, or you're not performing your part of a contract as per my expectations. So there has to be a clarity. Okay. And then these are the problems that I have with you, and in the next thing that we will do is mention his expectations from A, that when we entered into an agreement, you have agreed to do this thing at this date, that you have promised us a standard of work, or this is the manner in which performance is expected from you. So so this these things will be communicated from B to A. Okay, and this clarity will give A a perspective that how to go ahead with this matter now. Okay, next is, if in case A is ready to settle the matter, or A is ready to mend his ways as per the expectations of B, or he can come up with certain proposal that, I will take two steps and you take another few from your side, and then we can come to a middle ground and we can try and solve this dispute. Even this can be done on behalf of A. So it gives both the parties a chance to settle the dispute before going to the court, and ensure that they don't end up litigating in the court. Or else, there is a thing that obviously, if both the parties are not happy, or they are not ready to resolve the dispute beforehand, then they'll just end up into the litigation. Let us understand what is the legal notice. Okay, what is the concept of it? So let us start with the structure. Okay, there's a framework, or the manner in which certain matters are conducted, or the forums. Every kind of a dispute have different forums. Okay, and depending upon their cause of action, the the jurisdiction, the place, the pecuniary jurisdiction, the courts are decided, or the forum is decided, and accordingly, certain framework is to be followed. So accordingly, a legal notice is to be drafted. Okay. Secondly, it is very important that it is drafted on advocate's letterhead. Anybody like a law student cannot send a legal notice. You can definitely assist a lawyer, but it will be sent on a letterhead of an advocate. Okay, this letterhead, the concept of it, where I'll explain it to you when I'm sharing the drafts. So next is, it holds significance in the outcome of a legal dispute or proceeding. Like I said, this is a stage that is pre legal proceedings. Okay, so it is an inconvenient period. During that period, if whatever facts are shared with the other party, or whatever things are being put up in the legal notice, they are going to be a part of your proceeding as well. So you have to ensure that you don't cook up any stories in the legal notice. Okay, you mention things to the fact, and you stick to those facts in the legal proceedings as well. Okay, and you are not contradicting of what you have said in the legal notice and what goes into the proceedings later on in the plaint, or in your affidavits, in your arguments, and the whole procedure of your litigation. Next is, as a lawyer, you are supposed to draft legal notice on the instructions of your client. Okay. Once the client come to your office, he'll give you certain instructions. He'll tell you what his problems are, and it is your responsibility to ensure that only the relevant facts are communicated in the legal notice to the other party. You need not open all your cards. Okay. Tomorrow, if the things get sore between the parties, you'll end up litigating against each other. So it's very important that you don't show up all your cards or how you intend to take the legal proceeding ahead. If You have to ensure that you keep important things to yourself and communicate only those things with the other party is supposed to know. Okay, and that is where it means that the sender's intention, okay, to undertake legal proceeding is what the intention of a legal notice is supposed to be primarily, and only that intention is supposed to be shared with the other party. And the last point over here is you have to ensure that the recipient is aware of sender's grievances and demands resolution for it, because that is what the legal notice is all about. Now, why do we need a legal notice? What is its importance? Now, as we have seen that it is basically the notices are sent only in civil disputes. Okay, you have to be very clear about this concept that only in civil disputes we send legal notices and not in criminal disputes, because in criminal cases prosecution is set in motion when you file an FIR or when you file a complaint before a magistrate, and then the prosecution will take it ahead, or the whole procedure is taken ahead in a different manner by the state itself and not by the private parties. As far as the civil disputes are concerned, only in these matters the legal notices will be served. Yes, apart from that, there are certain quasi criminal cases like check bounce, okay, or 138, the complaint or demand notice which is sent under the Negotiable Instrument Act, Section 138. Okay, under that a legal notice is mandatory notice. So we will have a format of 138 demand notice as well. We'll discuss it. So I want to all of you to be very clear with this, that legal notices are sent only in civil disputes and not in criminal disputes. Okay. So it is to formally inform the other party that you intend to initiate a legal action against them. And it is a formal communication with a specific format. Like I've said, that you have to be very specific, that you have to be very clear that you are just, giving them relevant information in the notice, and you don't give away too much. Okay. The lesser, the better. The specific and precise you can write a notice, the better it is. Okay, it will enable the other party to come up with some solution. You might end up resolving your dispute amicably out of the court, and you need not step to the court or spend years in litigating or fighting over a particular dispute that you have with the other party. Okay, now let us discuss the contents over here. So till now, are there any questions, any queries from anybody
We do have queries, Vishakha. We can take it up in a while.
later?
Yeah.
Okay. So let me just continue with the contents of the legal notice. You have to be very specific about who's the sender, okay, and the recipient name. If it is a company, or if it is a private person, then if it's a private person, then you have to write his name, his address. If it's a company, then you have to ensure that it is the authority holder. Okay, it is a CEO, or it is the signatory authority who is being addressed at a particular of a company. It should not be somebody who doesn't have an authority to reply um, um, okay, to a notice. It has to be somebody who is in a position to take the responsibility and act accordingly. So you have to be taking these things into consideration, that the name and recipient's address are very important. Then the facts are to be presented comprehensively. Like I've been saying from the beginning itself, you have to ensure that all the relevant details are included. Then you have to take care that the time frame, or if in case there's certain limitation time, okay, that 30 days time left as far as the demand notice is to be served for in bounce cases, there's a limitation time frame that is to be followed. So you have to ensure that you follow that time frame. Okay. Then the means of compensation for the receipt. Like I said, that if you want the other party to pay you compensation for the loss or that you are suffering, or because of or any of the consequences that you have suffered. So it can be in terms of compensation, or it can be in terms of performance. So whatever is your demand, you have to ensure that you put it in the notice very clearly. Okay. Next is the mode of transmission. That will actually determines the cost of a legal notice in India. It is important to understand whether you're doing it through RPAD, that is the register code address, or you're sending it through a simple post, or if it is a speed post. Okay, all of that is very important. And these are the relevant, somewhere we can say, which are the recognized, okay, recognized modes of delivery of a notice. Also, you can also send a notice through WhatsApp and email, but as far as the relevancy is concerned, it is to be accompanied by sending a physical legal notice through post or speed post. Okay, or else sending only a notice through WhatsApp or email will not give you that recognition. Then it should be signed by an advocate. As I've said, that a notice is sent on an advocate's letterhead, and it should be signed by an advocate. If it is not signed and duly stamped, then it will be deemed to be a void notice, and it will not have that recognition. Okay. Now about the statutory notice and practice. Okay. See, sending a legal notice is something which is not a mandatory thing. Okay. It is something which has been developed through practice. Okay. But there are certain notices which are statutory notices. Like if you are intending to file a suit against the government or a person who is a public officer, okay, in his official capacity, then it is mandatory that you send them notice 2 months, okay, prior to suing them. So that is a notice period where you inform the other party, which is given under section 80 of the Civil Procedure Code. See, like we are living in a welfare state, so the state has a responsibility, and we are all aware the concept of state under Article 12 of the Constitution of India. Hence, your intention is not just to sue the state. State also has this in intention to serve its citizens. Okay, so while you intend to take a suit against the government or against any public officer, you serve them with a notice and you wait for 2 months' time, okay, for them to act upon your grievances. If your grievance is addressed by them, they will give a reply to you. And if in case the grievance is something which the government or any of the public officer is accepting, they will solve it as soon as possible. Or if in case they are willing to contest it, you will get a reply to that effect as well. So this is where a statutory notice is a compulsory or a mandatory notice under section 80 of a civil procedure code when you're filing a suit against a government or a public officer. Apart from that, there are other statutory notices as well. See, if you have there is a debt recovery tribunal, okay, wherein the assets of people who have taken loan and who have failed to repay their loans, then their properties are attached. Okay, so the kind of notices which are sent under section 13 of SAFESI Act, under that, again, these kinds of notices are termed as statutory notices. And similarly, other notices which are sent by the government or any other authority, okay, for that matter, like encroachment or eviction, all of these notices will be termed as mandatory notices. Okay, if you fail to address them or honor these notices, then some or the other proceedings will initiate against you. So this was the concept of statutory notice. I think you must have understood this. Now let us talk about the service. Okay. Now, what has happened during the COVID pandemic time? Okay, Supreme Court has allowed service of notices through fax, okay, and messengers like WhatsApp, Telegram, and Signal, everything. And there was this judgment of, I've also mentioned it here, SBI Cards and Payment Service Limited versus Rohidas Zadav, wherein the court also recognized that if the PDF attachment which was served was sent to the person on WhatsApp, he has opened it, then it will be termed as served. Okay, the notice was termed as served to the other party. But later on, it was taken into consideration by Supreme Court that sending the other person notice only through the like electronic mediums of WhatsApp and email is not enough. It is important that You also serve them with a physical notice through RPAD or speed post, okay, or such as Dusty or courier, which will be also considered as valid mode of serving notice. But the thing is, it should be physically served as well. Sending them only a WhatsApp or an email will not be termed as a valid means of serving the person with a notice. Okay, now we can sum this PPT first over here, and we can just talk about the points that you have to remember. That while you are drafting a notice, you have to ensure that it is short, it is informative, and it gives a glimpse of the important facts. Like for example, the notice of recovery of money on account of credit of sale. Okay, so if this can be a subject, or you have to ensure that in a small sentence you are conveying as much as you can. Okay, then the matter and facts. This part mentions the cause of concern notice, that the facts which have intentionally or unintentionally created a problem for the sender should be precisely stated, that it should be communicated properly to the other party. If there are any previous communication related to the matter, then that must also be referred. If you're replying to a particular notice, or if in case party A and party B had been in a long association with each other, and there are certain communications, some emails were exchanged or some letters were exchanged, then you have to give reference to that communication also. And again, no vital information related to the matter should be left out. Sender demands and requirements. You need to be very careful about what you are drafting in it. And if in case you are asking for a performance, you're asking for compensation, you are mentioning about mental harassment, okay, that you have suffered because of the conduct of the party, then you have to mention the facts, okay, that have led to this. Then the consequences will act as an intimidation. You have to intimidate the other party. So that, see, this, your action has led to this problem, and I have suffered this, and because of that, I want you to act upon it as soon as possible, or else I will settle the matter in the court, or take you or sue you in the court directly. You have to give them that time. Okay. Now that is it with the PPT. We can start discussing different formats. Are there any other questions?
Okay, so learners, we're going to get into the actual drafting now. Okay, so we're going to look into different kinds of legal notices and see how they are drafted. But before that, anybody has any questions with respect to the basics and the foundation that we've studied until now? If you have, please post it on the Q&A box. Okay, great. I think Vishakha, we can continue.
Okay. Okay, so the first notice is a very basic notice, a simple one, I will rather say. Eviction notice. Wait a minute. I'll just share my screen. The eviction notice. So, what has happened? I'll give you a brief of the facts over here. My client is a resident of Nagpur, and her property is situated in Mumbai. Okay. So, while having a conversation with her tenants, she realized that they intend to, extend their stay in her flat more than the time period which they have agreed uh, to in their leave-in license agreement. So in that case, she asked them that they have to honor the agreement and they have to leave the premises at the end of 11 months. But they kept on insisting that they want to enter into another agreement. So to ensure that there is no dispute between the parties later on, beforehand she asked me to send a notice to them. So this is what a notice is. This is regarding vacating and handing over peaceful possession of a flat. So instead of um, because she knew that the family of the person, or Shivam over here, wanted to extend their stay in a flat, so safer side, she sent them a notice, and in the 10th month itself, okay, a month before the agreement was supposed to get in. Okay, so these are the facts of the case. Now you can all see my screen. You can see over here that this is the letterhead that I was talking about, or that I mentioned to you, that you have to ensure that the notice is being sent on the letterhead of an advocate. Okay, so in the in the header, you can mention, I've mentioned my name, my qualification and designation, that I have a license to practice as an advocate. And here I have mentioned my official address. Okay, that's where the office is situated. then number, and my email ID. So this is how a letterhead is. You can also beautify it. You can mention it here on the left hand side, and on the right you can mention the address. You can. It is not any strict rule that this is how you have to do it, but yes, you have to ensure that you make a proper letterhead, okay, and over that you get your notice printed. Now, yes, the first thing after that you do is mention the means, okay, of publication, of sending it to the other party, whether it is a post or a paper publication. How you are giving a notice to the other party, you have to mention it at the beginning of the notice. Then comes the date, okay. Then the person, the sender, his name, detailed address. Now, this address has to be your postal address. You have to mention that. If you are sending a notice to the proprietor of a particular firm, then you have to ensure that all the proprietors' names are mentioned. Okay, over here, the agreement was entered between this person and his wife. Okay, and Meera, who is the flat owner. So both of their names are addressed here in the notice. Then the subject, vacating and handing over peaceful possession of a flat. As I said, this is about the eviction notice. So I have ensured that the subject is mentioned in a as short manner as possible. It is not compulsory that you have to make a short subject. Okay, you can, if you want, you can also write that this is regarding to honor the agreement which is signed between us. You can also mention that also. There's no hard and fast rule that you have to give it in a short manner. You can give more details and make your subject more specific. You can do that. Now, this is important. Under the authority and instructions of my client, Miss Meera, I have mentioned it. As we have seen in the PPT also, that you have to be careful that you give or that you give a notice to the other party under the instruction of your client, right? So to mention the same in the notice, you have to say under the authority and instructions of my client. Okay, then you give her address, and then I serve you with the following notice, and then you mention the other relevant details. Now, in the first paragraph, I have mentioned about the immovable property, okay, that where it is situated. Then that we have entered into the leave and license agreement. Okay, this is the date on which it was executed. Then the period, the time period is of 12 months, and I'm not interested in renewing it. So I want you to hereby um, honor the time period that we have entered into in the agreement, and I want you to leave the premises within the time and hand over the premises to me with and along with the interest-free refundable deposits after that. That is what I've mentioned here. Now, these are the important things. So in para 3C, in the first paragraph, details of the premises. In the second paragraph, that we have entered into an agreement. And so there is no dispute about it. Okay, these are the facts which both the parties will agree to. And the third paragraph, I've just given away my intention that I don't want to, continue or extend the time period of our agreement, live and license agreement. I want you to leave my premises, and once you give me the possession, I will give you the deposits and settle the dues with you. Then the other important things regarding that, and over here, failing which, okay, if in case you do not hand over me the peaceful possession of my property on the date of its expiry, then failing which you notices shall be liable to pay damages, compensation to my client to the double of the amount of license fees. That is this. So this is the way, okay, now the double amount or the triple amount is my choice or the client's choice, not my client, but the choice of my client. Then that is, and how do we come to this calculation? This is the we can say the problems which which she will face, or the because of that I might end up losing a new tenant, or there might be some other plans that I have, and just because you are not ready to leave the premises, I will face certain problems, and that is the reason that I'll ask you to pay me compensation for that. Then I might be having something else in my mind to do with the property. I might sell it to some other party. I might rent it out to somebody else. I can have some other plans about it. So first thing that is, if you do not leave the premises in the stipulated time, then obviously I will be facing certain problems, and for that I will ask you to pay me compensation and damages double of the amount of the license fees. So that is what I have mentioned over here very clearly. Okay, and it may also be noted here that the notices will be charged of rupees to 25,000 and are also payable by you noticee. Now this is to be these are the notice charges. Okay, now how you decide is notice charges, because if in case as we have seen over here. Now the other party, or the one who is sending, if the other party is not ready to honor the notice, or understand the problems that you might face, then in that case you will be suffering for certain um, any kind of problems. Then in that case will have to send them a notice. So because to avoid that, to ensure that you don't end up going to the court and litigate with each other, this is what you are serving them with a legal notice. So this is here, and then the advocate, like this is over here, I have to give my signature, as you have seen the PPT as well. It is mandatory that a notice is sent on the letterhead of an advocate, and it is signed by an advocate. So once it is signed, it is a properly deemed notice. Now, there are certain things which I want you all, to consider or to take into consideration while you are drafting a eviction notice. Okay, you have to ensure that the tenant's name and address are correct, then the landlord's name and address is correctly mentioned, the date of a notice, reason of eviction. So this is the reason of eviction is something which you have to take into consideration. See, when it comes to eviction notices or any kind of other notices, it can be of a residential property or a commercial property. You have to ensure that you're well versed with the local laws. Like in Maharashtra, we have Maharashtra Rent Control Act. So when you want other party to leave the premises, like we have seen over here, that the stipulated time period within which, which was agreed between the parties was over. So you ask the other party to leave the premises. If in case they have not honored, or in a way they have violated the laws, the clauses that the parties have agreed to in an agreement, then that gives you a reason to ask the party to evict, to ask the tenants to evict the premises. If they have agreed to use a residential premises into from you, and later on converted into a commercial, using it for a commercial purpose, then that gives you a reason for eviction. So you have to ensure that you're well versed with the basics of the local laws when it comes to eviction, and accordingly you can mention about it in the notice as well. Okay, then you have to give them a particular time period. Okay, that today I'm sending you a notice, tomorrow you vacated. That is not how things will work. You have to give them sufficient time to reply. Okay, sufficient time to vacate the property. Okay, and if about rents and areas or damages, if anything that is applicable, you have to ensure that you mention that very clearly in the notice. Okay, and the landlord signature. So these are certain things which you have to take into consideration. Next, there are certain, like I've said, Maharashtra Rent Control Act, because that we have it here in the local laws, and transfer of property. These both acts are very important whenever you're drafting a legal notice about eviction. So this is about the legal notice on eviction. Are there any doubts, any questions? Then you can ask me.
Yes, Vishakha, we have some doubts. Okay.
Okay.
So a lot of people are still asking about eviction notice. So if you could just please repeat what
Hmm.
eviction notice is, what is the definition of eviction notice, and
Okay.
also the case that you've mentioned about of eviction notice.
About the facts of this case, again, you want me to explain it? Okay, I'll just brief it
Just
to you
briefly,
once again.
please, just briefly explain about the eviction notice one more time to everyone.
Okay, okay, I'll just do that once again. See, over here, what has happened? My client is a resident of Nagpur, okay, and her property is situated in Mumbai, okay. So both the parties, lawyer Meera and her client, her tenants are Shivam, okay, and her wife and his wife. Both of them have agreed into a leave-in license agreement with Meera that we will be staying in your flat for a period of a year, okay, for 1 year. And later on, it was communicated or got a call to Meera that they intend to extend their stay. okay, or they want to enter into another agreement with Mira. So because Mira had other plans, she didn't want to extend their agreement with them. And so instead of getting into fight with the other party, she decided to send them a notice, okay, that you vacate the premises and hand over the peaceful possession of a flat to me within the time period which is already agreed between us, and I'm not inclined in extending our um, um, leave in license time period that we have agreed to entered upon earlier. Is it clear to all of you? Are the facts clear to you? Are there any doubts? Are the facts clear to everybody?
Yes,
Then,
Vishakha, we can move ahead.
okay. Is it clear? Okay, I can see that now. So after that, while I'm sending this notice, I'll address it to the tenants. Okay. And then I'll mention the subject that it is about vacating and handing over peaceful possession. That is what I intend to. Okay. Next, in the first paragraph, what I've done, I've mentioned address of my client. She's, as I've said, that she's a resident of Nagpur. Okay, so I've mentioned a Nagpur address over here. Under the authority and instructions of Mira, I serve upon you the following notice. Then in the first paragraph, I've given the details of the flat, okay, of which I want possession. This is the immovable property and the address of the flat. I've mentioned it. And then in the second paragraph, I've mentioned that you and I, okay, that is the tenants and the owner, both of us, have entered into an agreement that that you will be using this flat for residential purposes, this premises for a period of 12 months. Okay, that was agreed between the parties, and that detail I've given in the second paragraph. Then in the third paragraph, I've mentioned that this time period has not expired, so I want you to vacate the premises and hand over the peaceful possession, and I do not intend to extend this agreement with you any further. Okay. If in case you fail to vacate the premises, then you will be liable to pay certain damages and compensation to me. This is what I have communicated to them. Okay. And if in case you fail to do that, I will, the damages and compensation is something which I've asked the party. And how will I, ask them to do that? I will definitely take appropriate steps like filing a legal proceeding or taking them to the court and then asking them to vacate the premises and handing over it to me to the proper, before the legal forum. Okay. So in a way, I've tried to communicate it to them that I want you to vacate the premises. And if you don't do that, then I definitely intend to take you to court. So that is what I have mentioned in the sixth paragraph over here. Is it clear to all of you now? Are there any doubts? Yes, yes,
Okay, so what exactly is eviction notice? Eviction notice is asking the tenant to vacate the
premises.
property. Yeah, the property of
Property.
the
It can
tenant.
be a residential property, it can be a commercial property, whatsoever it is. That is what the eviction notice is. Okay.
Okay, great. Great, we can proceed, Vishakha. There's
Okay.
one more question, sorry. So Shruti is
Hmm.
asking, is it the sender's address that we write or the receiver's address?
Acha, in two, you send it to the receiver. Okay, whom you are addressing. That I want you are under the possession of my property, and I want you to evict it. So you have to address it to the person who is under the possession of your property. Okay,
It's basically the tenant.
it is the
Okay,
tenant.
great. Tapiva is asking, why should the landlord sign the notice? Is it not the advocate who should sign the legal
It is
notice?
the advocate. It is the advocate who is signing the notice. You can see it in the see over here. Okay, it is an advocate who is signing the notice. Any other questions?
Uh, Kamakshi is asking, can the other party give a counter notice?
Counter notice? No, they'll give a reply to the notice. Wait, I'll show you a reply format as well.
Okay, we can
Okay,
proceed.
we can do that. We can proceed with the reply.
Yes.
Can you see my screen?
No, the screen is
No,
not
just
visible.
huh. Now can you all see that?
Yes.
Okay, so over here again it will be on the letterhead. Okay, it will be to the person, it will be to the advocate, because you have received a notice, like we have said, that when you send a notice, you send it on a advocate's letterhead, right? So when the other person is replying, it will be from his advocate to the to you, okay, to your advocate. That is how things will go. It will not be served to you in a personal capacity, but will be sent to your advocate. So I will get a notice because as we have seen that it was signed by an advocate, so you will get a reply This will be in an address. Okay, and for in the first paragraph, you will mention that this is with respect to the legal notice that you have addressed to me. Okay, and then what you will do, you will give them a para-wise reply in the first and second para, and like in the previous notice we have seen that I've mentioned about, the basic facts, that this is where the property is situated. In the second paragraph, the relationship between the parties. So over here you can just mention that no reply is necessary, as these are the facts which are agreed by both the parties. Then there's no specific reply necessary to that. Then in para 3 to 7, there are certain disagreements that we are not agreeing with certain facts. Then those facts are to be specifically mentioned. In that, you can deny certain facts, and you can also plead, or you can just also mention your version of facts or your kind of a story while giving a denial. So while giving a reply to a notice, that is how you do it. Okay, you reply to a notice, you mention the notice addressed. Okay, and then you can just go ahead and start addressing the allegations or contentions which are made, okay, by the other party. If there are certain facts which you are agreeing to, you need not say anything about it. You can just agree to it. And then if there are certain things or certain facts which you are denying, and you have another version of your story, then you can just mention that very clearly in the reply. Okay, this is how you do it. And then you can tell that, hence, like you have said, that whether you send them with the notice, that this is how you can mention it. That hence, by your calling by the legal notice upon my client is hereby declined. That you sending me a notice, I am declining it. That rather, I am serving you with the notice, and I am giving you this uh, you know this information that you are the one who have wronged my client. And it is very clear with the facts that I've mentioned over here that you have failed to adhere the terms or conditions or time limits, whatever like your kind of a story is. If it has been alleged upon you by the other party that you have not done your part of a performance, then, and if you are not agreeing to it, then you have to mention it in the facts. Okay, that it's not me who have failed to perform his part of a contract, but it's you who have failed to perform your part of a contract, or you have failed to honor your word, and you have not followed the time limits in the agreement that which was agreed between us. So you have to mention that, and it's not me, and it's about that how you have taken ahead the work or performed your role. And you have to very clearly mention it in the notice. And this is a last attempt that I'm trying to make. And if you do not mend your ways, or you not work accordingly, then you will have to face certain consequences, and definitely we will take you to the court. You can also mention that in the reply to the notice. Are there any doubts about this? I'll just take you through the format of reply to the notice once again. Okay, over here, while you're replying to the notice, it will be to the advocate. Okay, who's on whose behalf you have already been served with the notice. You will be replying to that advocate that this is with reference to the notice that you have sent to us on this day. Okay, you have to give that reference. Then all the allegations that you have made are being denied by my client. So now this is again because this conversation is now going to be between two advocates and not the client or a private party. Then again in the first and second paragraph, like I said, if there are certain basic facts which are mentioned, which are not there's no dispute about it, you can mention that. Then other facts regarding which there's a dispute, or you have a version of a story, you have to mention it as a reply to those paragraphs. Okay, and you can share your side of facts or story with the other party, that I'm denying this and this is what has actually happened, and I am declining your legal notice, wherein I am serving you with I am giving you this opportunity to mend your ways and act upon your part of a contract, or your act on rather work on your performance of a contract, and that is how we can mend ways. Or else, I also intend to take a legal course or initiate a legal action against you, and then you will have to face the consequences of the same. So that is what. So what will happen? What has happened in the reply as well? The other party has ensured that they give their intention very clearly to the other party. That if they are not ready to comply with the notice, then definitely we are going to meet in the court, okay, or we are initiating legal proceedings against each other. This is it about the reply. Are there any doubts, any questions?
So,
reply.
Vishakha, I think before moving to the next type of notice, maybe we can
Hmm.
just address few questions. So,
Yes.
Sachin is asking, are the notice charges to be paid by the sender or recipient, including the advocate fees?
Including the advocate's fees.
Who
I,
pays?
I missed on the question, Akanksha. Will you please repeat it?
So Sachin is asking, who pays the legal notice charges, the sender or the
Okay.
recipient?
Okay, see, this is a formal way of mentioning it, okay, to the other party that because of your action, I have suffered certain losses or certain problems, and I want you to compensate for that. So it is not directly given to it. These are the how you calculate it, but the damages which have been caused because you have to go to a particular lawyer and you have to ask them to send a notice. This is what is included in the legal notice charges.
Okay, great. Um, Then moving to the next question. So Shruti is asking, it's almost like the similar question, so I'm asking together. So if the opposite party does not vacate the property or declines
Hmm.
the notice or does not reply to the notice, then what
Hmm.
happens? Do we get the damages? What happens?
Yes, then obviously you can just file a suit or present a suit. That is what how a suit is instituted in the code of law. That you file it in the court, you convince the court that a wrong has happened, the cause of action is there, and a case is being made out against the other party, and the other party will be sent a notice of complaint and given an opportunity to file their reply. And that is how you have to take ahead the legal proceedings, and that is what you have to mention in the notice as well. Okay.
Okay, Akriti is asking why legal notice is not sent in criminal cases.
Okay. Akriti, I have also explained. I'll give it to you in a very brief manner because a civil wrong and criminal wrong. Okay, we have understood this concept. Civil wrong is a wrong against a private person, and criminal wrong is right in rem and right in persona. Okay, so when a right in rem, that is right against a society, is violated, there is wherein the state comes into picture. But when it is right against persona, then it is a private person, then a civil wrong has been committed. Okay, so if it is a criminal wrong, that is a right against a society has been violated. Wherein, see, even if in case some theft has happened two building away from you, you will be scared in the night. So that in that kind of intimidation or a kind of a fear that is instilled in a person's mind, wherein a state takes a responsibility to address such problems. So when it is a criminal problem or a criminal wrong, then an FIR is filed or a complaint is made before a magistrate, and that is how a prosecution is set in motion. So a private person has nothing to do in it. Obviously, the all the initiations are done by the prosecution or the state itself.
Okay,
Akanksha,
great.
I
So
can't hear you.
Kamakshi is asking, is it mandatory to reply to the notice whether they accept it or decline it?
It is not mandatory. Okay, it is not mandatory. Generally, it is a part of practice that you have to. There's no mandate unless and until it is a statutory notice. There's no mandate to reply it. It is your choice whether you want to reply and you want to settle the matter. Okay, see, dialogues make things easy between the parties. Okay, but if there's no communication, if the other party doesn't know that you intend to take them before the court, or you can settle it. Okay, outside the court without spending years in litigation, then it is easier that way. So if both the parties are ready to cooperate, that will make things easier for them. So there is no mandatory rule. It is a part of practice which has been developed over the years.
Okay, great. Let's take two more questions.
Mhm.
So one anonymous attendee is asking, if I'm served with a notice, then do I have to approach an advocate to reply to the notice or can I do it personally?
No, you can't do it personally. You have to do it with the help of an advocate. It is mandatory, okay, that a legal notice is sent on a letter of an advocate, because there are certain. See, I'll give you a basic logic behind it. When it comes to why it is mandatory to send it on a letter and of an advocate is because a normal layman is not aware of the legal basic legal knowledge that is required, or the consequences that you might face because of not knowing or not being aware of certain things. Hence, it is important, or it is mandatory, that a legal notice is sent on a lawyer's letterhead, and it is not to be drafted by a normal person, except for the fact if a dispute is of a such a nature wherein a person can take it ahead, like of a consumer protection. If there is a consumer wrong which has been happened, any deficiency in service or a product that you have a complaint regarding that, then definitely you can just address it to the company. You need not need a lawyer for that. But if it is something regarding the civil disputes, then you need a lawyer for it.
Okay. Last question. Durga is asking. We'll address your other questions a little later, but we're just taking one last question. So Durga is asking, can we write in the reply notice, no reply necessary?
In the reply notice, no reply necessary. If you want, you
Yes.
can mention that. And yes, if it will be better if you just give them a reason that why no reply is necessary. Okay, you can just
And
mention it out and give
just to add to that, the reply notices have a format, so you have to
which is
stick
to
to
be
that
followed.
format.
Hmm.
Okay, so even if you want to say no reply necessary, please write it like, give a parawise reply and say that
It is
there's no
mandatory.
reply necessary because of so and so reason. Okay, so just that one sentence will not work.
Because you will face that consequences, Kanksha, later on in the court. If in case there's no reply is necessary and the parties intend to take it to the court, then in before the court, see, it's very important that you establish your goodwill. So your conduct while sending notices and later on in the court is very important. So having an arrogant and non-cooperative stand before the court proceedings will not help you before the court.
Yes. Okay, great. Please let's continue, Vishakha.
Okay. So now I have one important notice that is, like I have said, like in criminal cases, like we have a question, there is no legal notice sent. But in check bounce cases, which is termed as a quasi-criminal, okay, we do have a legal notice that is mandatorily to be served to the other party. So I'll be sharing the format with you. Just give me a second. So I am sharing my screen. I'll just give you a brief again about the format. It is a letterhead, okay, that I've mentioned my name and as my qualification and the fact that I have license to practice as an advocate. Then the modes of service, okay, that it is by speed post on register RPD that I'm intent to send this notice to. Then the date, okay. Then two, the person. Now over here, the person, okay, is the other party is a proprietor. Now I'll give you the brief of why I've sent this notice to this party. I am a um, biopharma. Okay, I am a company um, who have its registered address in Nagpur. Okay, and I make like medical drugs. Okay, so my work is I have been in a relationship or a commercial relationship with this medical agency to whom I send uh, medicines on regular basis. Okay, it's been a long time, and they have this tendency of repaying me later on. So what I do is I send them their drugs or their medicines beforehand, and then a bill is sent along with it, and they clear my bills later. But now it has been repeatedly like twice or thrice that they have not paid me my bills, and they I've been sending them the medicines as and when they have asked for it. So because later on when they've sent me a note, a check, and that check was not honored for insufficiency of funds. Okay, so because of that, later I have sent them this demand notice. You can see that I've started it like this to Mr. Sanjay. Okay, he's a proprietor of medical agency. Like I said, that when you are sending a particular notice to a private person, then you have to mention his name, address accordingly. If it is a person who is in an official capacity, okay, of this medical agency, this person is a proprietor. If there are two or three proprietors, then I have to mention all the three names, okay, and their designation of how they have the responsibility to answer to my notice. So the designation is very important. The postal address and PIN code is important. I have to mention that. Then under the instructions of my client, okay, I serve you with the following notice. Then who is my client? This biopharma. Then I have given the address, that is the registered office where they have. I've given that address, okay, and then I serve you with the following notice. Now in the first paragraph, what I've mentioned, that I have mentioned their name, okay, and the business that they are involved in. In the second paragraph, I've mentioned that I have, okay, I've worked upon it. I've ensured that I mentioned about the reputation and the goodwill of business that my client has built over the years in Maharashtra. Then you are this agency that we have entered into an agreement. I've mentioned that. Then regarding the transaction between the parties, okay, that seeking supply of certain products in course of business and on number of occasions, and I've always supplied you with it. So this is where I am putting up that my side of a contract or whatever we have agreed upon, I've been very diligent in my work. Okay, that is what I've tried to establish. So in the very first paragraph, I've mentioned about that registered address, that I am a medical agent, that I am a pharmaceutical company and I'm producing, okay, medicines. Second paragraph, the transaction or the relationship between me and you as a medical agency. In the third paragraph, this has been our business for a very long time, and I've been diligently supplying you medicines that are required by you from time to time. I've mentioned that. In the fourth paragraph, the cause of action. Okay, now the cause of action, in which you have to mention all the important facts. Okay, that I have raised 3 invoices. Okay, and those 3 invoices, I've mentioned the dates of those invoices over here. Hmm? And then the amount also. So you have to be very specific about this. And this is what I want to communicate with the other party. This is where the problem lies now. Okay. That I've sent you 3 invoices dated this and this of amount that and that. Okay. Then you have come with the reason of not paying me, that it is pandemic and you are facing certain problems and you are not in a position to pay me for the invoices or the bills that I have sent you. Though I have made several attempts, okay, I've called you telephonically, I've sent you mails, but you have never replied to it. Okay, I have repeatedly asked you. It doesn't mean that, see, just because you have not answered or you have not paid any bill of mine, it doesn't mean I'm directly, sending you a legal notice. I have tried my hands in making all the attempts. Okay, I've called you, I've sent you mails that you honored this. Okay, that you ensure that my bills are cleared as soon as possible, but you have not taken a single attempt to clarify or to give me a clarification or anything. Later on, after persuading you, you have sent me a check. Okay, I've mentioned the check number and the amount number and the bank name over here. Okay, and that I have deposited this check and it was dishonored for the reason that the account was closed. Okay, so you ended up giving me a check of a particular account which was closed. So this shows your intention of not, okay, honoring your word and not giving me the or clearing my bills over here. So I call upon you to pay me within next 15 days. See, when it comes to the demand notice now, there is a time period which is mandatorily to be followed by the other party. So I'll explain you about this time period also. Just I have mentioned it over here. Whenever you're sending a demand notice to the other party, okay, you have to ensure that on the date of dishonor, the demand notice is sent within 30 days. For example, if a check is given to you on first, okay, and you deposit that check and it is bounced on second or on third, whatever date it is. So within that, from the next 30 days, okay, from the 1st of December till it is deposited in the bank on third, then before 3rd of January, after dishonor, I have to send them a demand notice. Now, after receiving this demand notice, okay, I'm sending a demand notice supposedly on 2nd of January. Okay, I have the whole month's time with me. Within 30 days, I have to do it. I've sent it on 2nd of January. Then the other person must have received it on 5th of January. We can say that. Now, from 5th of January till 20th of January, the 15 days time is with them to comply with the notice. And after that, if they fail to comply, then within next 30 days, I can file a complaint before the magistrate. Okay, under 138 of Negotiable Instrument Act. In that, I have to consider the cause of action and the place of jurisdiction while filing a complaint. I'll just repeat it again. Once a check is given to you and when you deposit it in the bank, it is dishonored. Okay. Then from the date of dishonor, within next 30 days, you have to send a demand notice. Once the notice is received, that is to be honored in next 15 days, that you have to comply with the notice. Okay. Within next 15 days. After the expiry of 15 days, if the notice is not complied with, then you can file a complaint under 138 of Negotiable Instrument Act to the magistrate. Is it clear whether the time frame of NI Act is clear to you? Okay, this is a mandatory notice, okay, that you have to send to the other party in case a check bounce happens, and there is a complaint which is to be filed. So before that, you just today a check has bounced. It doesn't mean that tomorrow you'll go and file a complaint before the magistrate. Okay, that is not how you're supposed to go ahead with the demand notices. Sorry, with the matters, but you are supposed to send them a notice first after a check is bounced. So I'll just repeat once again what we have covered. So if in case a check is bounced, okay, then you are supposed to address the party, okay, from whom you have received such a check. Okay, you have to again start as under the instructions of my client. I serve you with the following notice. You have to mention the details of your client. Then you have to talk about the relationship between the parties. Then the transaction that has happened when you are addressing the check or the invoices. Okay, then you have to give the dates and the amounts very specifically. You have to address that. And in respect to that, if you have received any check which is bounced, that is what a demand notice is all about. You have to give very clearly the details of the check. Okay, I will give the number, you will give the bank name and the amount and the date on which it was given to you. If that, and then again, the next thing that comes in is the date on which the check was dishonored. Okay, you have to mention it very clearly. Once it is mentioned, then you have to clearly tell that I'm giving you 15 days time. Okay, because that is the mandatory time which is to be followed as per the Negotiable Instrument Act. 15 days period is given to the other party upon receipt of the notice that you have to comply with this, or else what will happen? I will take you to the court. Okay, and you have to very clearly mention your intentions over here without disclosing much of a detail. Okay, this is how you go ahead with it. See, over here, I've mentioned very clearly that I will file a complaint under 138, or I will have recourse to other civil and criminal proceedings also. So it is up to me what I have to take ahead against you. Okay, what kind of proceedings I intend to take against. And finally, it will be signed by an advocate. Yes. Are there any questions, any doubts about the negotiable instrument notice that we have sent?
We have overall doubts. I think we are
Yes.
now done with the session also, Vishakha.
Yes,
So
yes.
we'll address different kinds of questions that are pending.
Okay.
We have covered different kinds of notices as much as we could in this duration of time. Let's address some questions. One second. So, Shruti is asking what happens till the time the proceeding is going on. Okay, Shruti, you'll have to be a little more clear with your question. In the processes that you send the legal notice, you give them a particular duration of time to reply. And in case if they're not able to reply, or if they reply and decline your legal notice, then of course you have the opportunity to go to court and start the proceedings. That's the process. Okay. So if you have to know anything else, please write your question in a more detailed manner. I'll address them. Okay. Umbul is asking, in the reply of legal notice, the name of the other party's advocate has to be there after two.
In reply, will you
In
please repeat
reply,
it?
so I'll answer that, Umbul. So in after two, you have to write the name of the opposite party, not the advocate.
I think he must have got confused because I've also shared the format of reply, Akanksha. So when you're giving the reply, you give it to the advocate.
Yeah, when you sending the
Huh.
notice to for the first time, you're sending it to the person, the opposite party.
Mhm.
And because the legal notice is sent on behalf of the party and the advocate signs the legal notice, so when the opposite party's lawyer is addressing the reply, he is addressing it to the. I hope that is clear now, Umbul. Okay, so Adona is asking, what steps can the plaintiff take if the defendant refuses to accept the notice?
You can definitely, file a case in the court and take legal proceedings against them. See, when you go to the court, again, it is very important. That is the reason I've been insisting that you have to be very specific with the facts that you are pleading, okay, or the facts that you have been stating in the notice, and do not open all your cards or tell the other party what your intentions are, because that gives you an upper hand when you are going to the court. When you go to the court, you have to convince the court also that a wrong has committed. Okay. And the wrong is of such a nature, a legal wrong has been committed against which you have certain remedy available. So that is once the court agrees to that, okay, that yes, wrong has been committed against you, and there's a remedy available which the court has the power to grant you, and then other party will be sent for summons. Okay, where they will be told that this is what you have committed wrong against the other person that has been alleged against you, and we request you to come and address to the allegations and contentions which are being made against you in the court on this date. So that is what the legal proceedings will go ahead.
Okay, great. Thanks for that explanation, Vishakha. Okay, now moving to the next question. Sachin is asking, before initiating the notice, should we inform the other party about the disputes and the intention to give notice against them?
Yes, definitely, you can do that. See, when there is a disagreement, okay, when the disagreement between the parties, or you are insisting on a certain thing, you're definitely making certain calls, you're sending them mails, like in a demand notice, that you are not making me the required payments, Baba. If you give me the payment, then I can send you okay, the next demand that you have asked for. Like in the eviction notice as well, that we have seen, that I want to vacate the premises because I intend to use it for some other purposes. Now you need to communicate it to the other party. The other party will be caught unaware, okay, if you just send them a legal notice directly. So it should not happen. If it is possible that you can just communicate it to them, and they're ready to can listen to you or whatever problems you have, then definitely you can try your hand on it. If because of their non-repliance or non-compliance and their ignorance, you have then a reason to send them a legal notice that, see, you have been not listening to me, or I've tried to communicate it to you a number of times and you have failed to do that, give any reply to it, and hence I'm sending you a legal notice now, that if you don't mend your ways, I'm intending to take you to the court. That is what the purpose of legal notices.
Okay, great. An anonymous attendee is asking, is the subject not required in demand notice?
It is up to you. If you want, you can just mention the subject. If you don't want to mention subject, it's fine, that's not a problem.
Okay, great. Another anonymous attendee is asking, how many types of legal notices are there?
Okay, the kind of legal disputes are there. You can just legal dispute, that too also civil dispute. So if you want, like, I'll give you certain examples. Okay, like we have just covered eviction notice and a demand notice. Then if you have received a, if somebody is taking any kind of illegal encroachment in your area, then you can send a notice about it as well. If in case certain payments were not done to you, or you have any disputes with your employer, then you can send them a legal notice regarding that. It can be for promotions. It can, like in government services, we have seen for promotions, mostly it is sent to the employer. You can just mention that. So if it is for the kind of services that you have asked for and it has not been delivered accordingly, then you can send a legal notice regarding. So n number of problems that you have, or legal disputes which can be there, for all that things you can send a legal notice.
Okay, great. Ricky is asking, do we have to attach any kind of evidence in support of the statements mentioned in the notice?
No, no evidences. Just you have to be very specific about the information. Like I said, if it is a demand notice, na, then you have to mention the date. You have to mention the bank name, the date on which it was sent to you, the date on which you have deposited in the bank. Okay, and it was dishonored. All these information which are very relevant when you are addressing it a certain facts to the other party. Only that is to be given. It doesn't mean that you have to attach certain evidences to the other party. You will give evidences for checking, or to check its authenticity, or to about its relevancy in the court, and not to the other part, because you have to convince the court and not the other party over it.
Yes, absolutely right. Okay. Now moving to Khushbu's question. So if the notice is not served to the other party because their residential place was vacant, then what will happen? What do we have to do?
See, as far as the legal notices are concerned, you can try it sending it once on the proper address that you have. If it is not being addressed, if you don't have the proper address with you, or some any other means, you can send it. If you know where their place of work, then you can send it to their place of work as well. You can just, but you have to ensure that you do not address it to their employer, and you address it to that person itself. Okay, you should ensure over here that and no kind of defamation is being caused to the other person because of your actions, or else you will end up inviting any other legal problems for you. So you can just try sending it to the place where their alternate addresses or place of work. That is what the best you can do.
Yes, and you should go through Order 5 of CPC and go through all the different kinds of modes of service that you have to exhaust before you go to court. Okay, so publishing in the newspaper is another option that can be done. Okay. All right. If the accused claims that they did not receive the notice, but it was actually sent to their correct address, then what happens?
If it is then that leads to ignorance of notice, okay, and that is what their conduct is. So whenever you are initiating a case against them, or you have filed a case in the court of law, you can just put it to the court as well that you have tried your level at your level to address it with the opposite party, but they have been reluctant in replying to any of your questions, and hence you have come to exhaust this remedy of seeking before the court. So that is the thing that you have to go ahead.
Okay, Adona is asking, could you please clarify how the legal system views an individual who receives a legal notice? Are they considered to be an accused?
See, accused is a person. See, accusations are being made when there is that is what an accused person comes. Okay, that is where the word accused comes. That you have been there are certain allegations or accusations being made against a person, and hence he's an accused person in a criminal case. Okay, and not in a civil case. In civil case, everybody there's just agreement between the parties. Okay, just filing a case against C. It can be party A and party B. Both of them can be at a disagreement with each other. A will have certain problems, okay, that you have not completed a required work on a particular date. You have not, and B will have problems like you have not given me the full payment. A will say because you did not perform as per my expectations. So over here, nobody is at fault. Okay, they have disputes with each other. So if A goes to the court before B, that doesn't make B accused over here. Okay, B will say, "Arey, I'm the one who has suffered. You should pay me compensation." So this can happen. So in civil cases, as it is a wrong or against a particular person, okay, and that is of a civil nature, which can see civil nature again, a wrong which can be compensated, which can be computed. Okay, that kind of a wrong for which can be computed or can be compensated in kind of damages or in kind of performance. Okay, that is what a civil wrong is all about. Okay, accused and accusations are all about criminal nature.
All right. Okay. We have one more question from Sachin. Can you just throw some light on the SBI cards case and what was the Supreme Court's response? So, is like WhatsApp and email valid or not?
Yes, I'll just give you a clarification on that because see, during pandemic, we were struggling with a lot of things, okay, and the court, everybody, like all the authorities, try to support and make things easy for everyone. At that time, as there was a lot of restrictions on the kind of items which are being sent by post, okay, to avoid that infection doesn't spread. So they ensured that okay, if it is taking time, okay, at a particular day only particular certain parcels or certain envelopes were being allowed to send from one place, then they give at that time they gave a liberty that yes, you can send them through WhatsApp and emails also, and then through electronic means certain efforts were taken into consideration, that to ensure that the other person opened or not. Okay, all of that things were taken into consideration and things were allowed, but only during pandemic. Now in 2023, the Supreme Court registrar made it very clear that only sending it through WhatsApp or email, okay, to the other party will not be termed as a proper notice, as a valid form of serving notice. You have to also send it in a physical form, like have Akanksha has already mentioned that in Order 5 of Criminal for Civil Procedure Code, it is very clearly mentioned about the modes of services. Okay, for sending notice, it is not just for sending notice once the case is initiated in the code of law. That is the mode of services that you have. You can send it by post, you can send it through Hamdars, you can send an officer of a court. Okay, we have to request for it to the court, and accordingly you can just opt for any of the services. But as far as if you want to send it through any electronic means, that is not the only means of service which will be accepted, but along with that you also have to send a physical notice to the other party.
Okay, awesome. So let's address one last question, Vishakha, and then we'll be done with the session. Is it mandatory to give notice against public officers? And if yes, what if the like matter is very private to that public officer? Is it still mandatory? I mean, it's nothing related to office, but it's like a personal matter of the public officer. Then is it mandatory?
No, then it is not mandatory. Okay, if that public officer has done something in his official capacity, Okay,
Yes.
then you will address it to him. If it is something that is that is his personal problem, or you have any personal disputes with him, then his official designation doesn't matter. What he is, what he does at work, that doesn't concern you. You can address him that way.
Okay, great. Thank you so much, Vishakha, for simplifying all these different kinds of notices. We've tried to cover as many types of notices as we can, and you've really answered all the questions also with a lot of depth. So thanks a lot for that. Everybody else, I request you to now stay for a bit, okay, to explore this one, the bonus registration opportunity. So we're going to be starting now. All those who are not interested to know about this registration opportunity, I'm sharing the details with respect to the certificates, okay? I'll be sharing the link of the certificate with you. You can actually open that link and so this is the link of the certificate. Okay, if you want to, okay, Divya, thanks for your trust in us. Okay, but if for the certificates, this is the link for the certificate. You can use the code. I'm sending the code on the chat box. You can use this code. Okay. This is the code LLS 3-day webinar. You can use this code and your certificates will be given to you within a week. Okay, this is about the certificates. I hope if this clarity is over, and for everyone else who is not probably interested or has already bought the winter training program, can leave the webinar. Rest of you, please make sure you stay and explore this particular opportunity. Okay, for certificates, see, we personally don't encourage you to get the certificate because it has no value per se, but a lot of people actually want to show it in the college or just want to have that. So then we allow certificates at a small like a small cost, okay, just so that you understand that certificates of webinars per se is not something that, I mean, you should not be here only for the certificate. You should actually be here for the actual learning purpose and for the the other opportunities that we're giving. Yes, there is a small cost that has to be paid for the certificate in case if you want it. All right, now it's 12:30. Okay, so by the way, we'll be sharing this legal notice that Vishakha has shared. We'll be sharing one of the notices with you on the WhatsApp group, so don't worry about it. Okay, and all the recordings and everything will be shared with you. If you're not a part of the WhatsApp group, I'll be sharing the WhatsApp link with you. Please join the WhatsApp group in case if you have not joined it yet. Okay. Okay. So this is the WhatsApp group link that I'm sharing with you. Please join this link because we'll be sharing all the different kinds of the recordings and all the the PDFs, everything. I will share it in this WhatsApp group. Okay. All right. Now coming to the winter training program, the registration time has begun. Okay. I'll be sharing the registration link with you on the chat box. Please make sure you utilize this half an hour very carefully. Okay. Now the winter training program, we have three verticals in the winter training program. There is corporate, there is litigation, and there's budding lawyers. Budding lawyers is for people who have just joined the just graduated or are still in law school. Okay, and they want to do really well in law school. They want to excel in their law school and they want to do have a great CV. For them we have the budding lawyers program. Okay, the fees for the entire winter training program is 9,900, but you are here present at the most amazing and the most lucky time, because you will not only get the new year offer of rupees 1,000, but you will also get the webinar offer of rupees 1,000. So a total of 2,000 rupees is off for you. Plus, you will also get two complimentary courses for free along with this if you register now. Okay. The timings. Okay. Now, winter training program. So when we had the summer training program this year, we kept the classes were there during the day in the mornings as well. But this time we have not kept the winter training program in the mornings. We have kept it in the evening. Okay. Just so that you all of you, even if you're doing your job or if you're doing your classes, you're still able to attend classes every day in the evening. Okay. In case you miss out on certain classes and you're not able to attend the classes, then we will be giving you recordings of those classes as well. Okay, so no issues with that. Okay, now let me quickly share my screen and give you a little bit of an understanding regarding the winter training program. For all those asking for certificates, please scroll up a little bit. Okay, on the chat box I have given the link of the certificate, so please scroll up a little bit, you will find it. Okay, now we are focusing on the winter training program. For the winter training program, the reduced amount is given in this registration link. Okay, so if you register through this link, we know that you have been you are eligible for the 2 free courses that we have as well. All right, now let me share my screen. Okay, great. So as I said, we have 3 verticals: litigation, corporate law, and budding lawyers. Okay, and the 3 magical points, or the USP, which is common for all 3 verticals, is that we will have every week you will have career sessions by Mr. Tanuj Kalia. Okay, I had mentioned it yesterday also. Tanuj has probably gone through 5,000 CVs and he knows what CV works in the market. So he's personally going to take sessions for you to make sure you know how to draft an excellent CV, how to do well in your internships, what kind of internships, how to land good internships, how to get PPOs. All these training sessions will be there every week for you. Okay, plus you will have networking sessions by Mr. Aditya Aryan. Okay, I mentioned it yesterday also that networking is a huge skill which can help you get a lot of clients, which can help you get good good business of law. Okay, networking is not important only with the clients, but it is also important with your peers. You should know like how to actually talk to other advocates so that you can get cases. I mean, Vishakha will also agree with me that we have received a lot of cases from our friends because we've networked with them in that manner. Okay, so that kind of networking skill really changes your career by tenfolds. So that also session you will be getting every week. And the most important and the best USP of winter training program is that we have partnered with law firms in each vertical. Okay, so for litigation we have partnered with the litigation chambers. For corporate, we have partnered with corporate law firms. Okay, for budding lawyers, we've partnered with an excellent organization which all of you know about, where you're going to be doing research projects. Okay, in all of these 3 verticals, you're going to be getting the law firms. The partnered law firms are going to take sessions for you where they're going to teach you the basics of their research project, and then you will get that research project. You will be doing that project and submitting it, and once the research project is over, you will get a certificate from the law firm as well. So you will be getting 2 certificates from Loctopus if you do the winter training program. One is by Loctopus Law School and one is by the law firm. Okay, in fact you can get a third certificate if you do really well in the course. Then you will also get a merit certificate. Okay, which acts as like a recommendation letter from Loctopus. So you have an opportunity of getting 3 certificates. Okay, also if you register in this webinar, obviously you're going to be getting two more courses. So it's not just the 3 certificates, you're actually getting 5 certificates, because the 2 more courses that are there that we're giving you, those courses have a separate certificate each. Okay, are you all with me until here? Could you please provide the link again? Adona, which link are you talking about? Okay, the certificate link. Just a second. I'll give that. This is the link, and this is the link, and I'm sharing. This is the link, and I'm sharing the code also with you. Okay, just a second. I've shared the certificate link, by the way. I'll share it on WhatsApp. Don't worry. And I'm sharing the code again with you. Now, currently we are talking about the winter training program, so I really hope all of you do not you can take the certificate from the WhatsApp group. Okay, I'm again pinning the registration link of the winter training program, okay, again on the chat box. Let me share the Loctopus post of the winter training program as well with you, just so that you can get more details about this program through this particular post. Just a second. Okay, so you can find out more about it. The schedule is also given here. Okay, let me quickly give you a little bit of an understanding of what all the three verticals look like. Okay, all right. Now, in the litigation vertical, gradually over a period of 1 month, okay, the winter training program is starting on 5th of January. So, over a period of 1 month, you will be getting, to understand everything starting from the basics of litigation, where you will understand about the terminologies, what plaintiff means, what defendant means, what is district court, what is high court, what are the hierarchy of courts, what is a case brief, how do you make a case brief, okay, what is a judge's file versus what is a lawyer's file, plus how do you draft legal notices. Like, today Vishakha taught you, it was just like a small teaser of everything that we have in store for you, because we want to go in detail of the legal notices, right? So over a period of that 1 month, you will have classes with respect to legal notices. You will have classes both for civil drafting and procedure as well as criminal drafting and procedure, where you're going to be learning about drafting of plaints, written statements, evidence affidavits, interim applications. Then in criminal drafting, you'll be learning about 125 CRPC applications, section 12 DV applications. Then you'll be learning about appeals, review, revision, all kinds of documents which are necessary for a criminal advocacy. All documents which are necessary for criminal advocacy will be taught to you in the litigation vertical. Okay, in the corporate vertical, on the other hand, we will start with legal research and writing. You know how important research and writing is, so we're going to be starting with that, then move to contract drafting and negotiations, and we'll have separate sessions on negotiations by Tanuj as well, where we'll be discussing all the detailed strategies with respect to negotiations. Okay, we'll have classes on Companies Act, incorporation of company, drafting of AOA, drafting of MOA, registration of a company. Okay, and then we'll have law firm projects on mergers and acquisitions as well. Okay, so all very wholesome expert level learning in corporate training program. Then we have a training program for budding lawyers, where you will again be learning legal research and writing. You will have legal notice drafting also in budding lawyers vertical. Plus you will have you'll learn everything about mooting, drafting of memorials, research skills, argumentation skills. Okay, all by Mr. Jay Batruka Mohanta, okay, who's like one of the best faculties that we have. And you'll also learn about reading, finding and summarizing case laws. If you want to be a lawyer, case laws are really, really important. Okay, you should know how to find a case law, you should know how to research for case laws, you should know how to summarize case laws. All of this will be taught to you in the budding lawyers program, and the career sessions, the networking sessions and the capstone projects will be common for all three verticals. Okay, this is a replacement, like an equivalent of internships. Internships can take a lot of physical effort and financial effort. Okay, in this, through winter training program, we ensure that you are at home, at the comfort of your home. You're getting so many skills and you're getting internship certificates from law firms at such a reasonable amount. We've already kept the amount very reasonable, plus because it is like New Year offer and the webinar offer, the amount is reduced even further with 2 extra courses that you're getting. You cannot get anything better than this. Okay, so it's budget friendly, with an opportunity of getting 5 certificates, an internship certificate, and loads and loads of practical skills that can change your career, can literally transform the direction of your career. Okay, we've had many people who have done this done this summer training program this year, and I'm going to show you some of the just a little bit of like some people what they had to do. The fees is the same for all the 3 verticals, Pradeep. Okay, because we are putting in exact amount of effort. So 7,900 for you today is 7,900. Otherwise it is of 9,900, but for you it will be 7,900 plus plus 2 extra courses. Okay, we've gotten a lot of feedback from so Nikhil was a first year student. Okay, he really appreciated the summer training program. Then we have Mohammad Umar, okay, who's a fourth year student. After doing our summer training program, he has taken 4 more courses from Loctopus Law School. He says that this course has changed my perception that there are still people who focus on quality learning and not making business out of it. It was my pleasure to be part of STP program, STP summer training program. Okay, I had shown this yesterday also. Vignesh was again a fourth year law student. The course was designed meticulously, offering a perfect blend of theoretical and practical knowledge. Okay, so we don't forget the theory when we are teaching you practicalities. Okay, we have many more. I'll definitely share the feedback form with you, but before that I want to show you all a video. Please make use of this particular time. Okay, fee for all 3 verticals, or no, so no, Pradeep, I mean, the fee is for each vertical. Like if you want, I mean, 7,900 for one vertical. If you want to take litigation vertical, that's 7,900. If you want to take 2 verticals, so then 7,900 plus 7,900. Okay, so for each vertical, it is that amount. Okay, you'll not be getting all the 3 in that amount. That is not possible, not reasonable at all. Okay, all right. So I'll be sharing a small video with you. I wanted to show you. Okay, just a little bit of our summer training program and 1 or 2 2 months long program as well. Please have a look.
The one thing that I would like to say about Loctopus is that the teaching methods are very, very engaging.
The online sessions were interactive, and Akansha ma'am encouraged participation from all of us.
The management has always been on time, they reply to the mails really quick, and it has just been a phenomenal experience.
And my favorite program has to be the career session, because I'm currently applying the skills and the things that were taught. I'm currently applying them, and that landed me an internship, which is paid, my first paid internship.
The entire session, overall, a 1 month rigorous legal learning experience was entirely fruitful for me.
The best part which I found about Loctopus is that the approach is completely practical oriented in terms of teaching.
I thoroughly enjoyed the recorded as well as the live lectures. They are truly the source where you can gain knowledge and enhance your skills too.
Before joining these courses, I had no idea about drafting, and after completing the course of just 2 months, I am very confident about drafting.
Thank you so much, Loctopus Law School, and I wholeheartedly recommend this institution to anyone who is seeking top-notch legal education and practical skills in contract law.
Okay, great. So, as I had said yesterday also, okay, a lot of us just keep waiting for the best to happen with us, and we don't take action when the time is right. Okay, I don't want you to be one of them. When I was in my law school, I did not get something like this.